And closing arguments are set for today in the Karen Reed murder retrial. The 45-year-old is accused of running into her Boston police officer boyfriend and leaving him to die in the snow. The defense says Reed dropped John O'Keefe off at another officer's house party that night and that she's the victim of a cover-up. Now a new jury will decide her fate after Reed's first trial ended in a hung jury. Let's bring in AB's News investigative reporter Olivia Rubin and civil trial attorney Tre Lovell for more. Tre, during the charge conference yesterday, the judge discussed what each side can and can't bring up during closing arguments. What do you make of the boundaries they're up against?
I thought that was a good ruling with the judge. The defense's alternative theory that there was somebody else, Brian Higgins may have done this, I thought would have been problematic for them because it's a really credibility stretch. And plus, they didn't, reach their burden in order to be able to assert that somebody else had done this. So I thought it was a fair instruction, and I actually think it helps the defense by focusing on the insufficiency of the police investigation and their science and their experts. I think they're going to present more of a credible defense, that's going to preserve that and really focus that, this has not reached the level of reasonable doubt.
Tre, the judge also talked about the instructions she'll give the jury. The defense asked her not to include an instruction on consciousness of guilt. Why not? What's the issue there?
Well, consciousness of guilt basically says if Karen Reed is found to have destroyed evidence or tried to intimidate witnesses, there's an inference that she's guilty. And thus the jury can consider that in terms of whether or not they're going to find her guilty. And it's an instruction that can be dangerous and is necessary in the right circumstances. But I thought the judge was correct, and I thought the prosecution, in terms of not wanting to bring that, made sense as well. I think the instructions are going to be pretty solid here. Whenever you're looking at these cases, you always look at what may be an appellate issue, and the judge is being conservative about that. There's no out of bounds instructions, and I think that we're going into the closing arguments and then the deliberations pretty tight.
Tre, let's unpack this a little. When the prosecution gets up there, what are the key points you think they have to hit on to try to prove this case beyond a reasonable doubt? And I also want to remind the viewers, the burden is on the prosecution to prove the case beyond a reasonable doubt.
So I think the prosecution is going to focus on three things. First of all, what Olivia said, which is exactly right, those party admissions. The 3 or 4 people that Karen Reed allegedly told she hit him, as well as the interviews on television, which she indicated, I may have clipped him, I may have hit him. That is powerful testimony because that is coming from the defendant herself. They're also going to focus on those text messages and her state of mind the day of the murder or the alleged when he was killed, because she was upset and there was motive and intent that she would have done it. And then finally, the science. The prosecution is going to argue, hey, with respect to the science, we proved that O'Keefe was hit by this vehicle. We had criminologists, we had DNA experts, we had forensic pathologists, we had neurologists, we had accident reconstructionists, we had digital experts. A number of experts all came with the same conclusion. He was hit by a vehicle and his injuries matched that impact. And it's going to be pretty compelling.
And then on the defense side, they don't have to prove their alternate theory here. They don't have to prove that John O'Keefe was attacked inside the party or that somebody else specific did this. They just have to show the jury that there's enough reasonable doubt to call into question what the prosecution is saying happened here. So what do you think they really have to land in order to make that happen?
So what the defense is going to focus is on 2 things. First, the insufficiency of the police investigation. They're going to say it was sloppy, it was lazy, there were predeterminations made, you can't rely on it. And then they're going to rely on the science. They're going to say, hey, our experts, you listen to the prosecution's experts, our experts took it a little bit further. You had our experts who evaluated the impact with actual force at different speeds. Our experts took what the accident reconstructionists did on the prosecution side and said, hey, even if you did that, the damages and the injuries would have been much more severe. There would have been broken bones. There would have been more severe damage to the skin. So they're going to say, hey, the prosecution put on their case, we took the science further, and all of this leads you to one conclusion, reasonable doubt.
But none of that is supposed to come into play today, Tre, not those outside conversations. This is about what happened in court throughout this specific trial, not even the last one. And so The defense has said that they're going to focus on this argument that the investigation was botched. How far do you think they'll go into the why there? How far do you think they will go in arguing that there was collusion here because this happened at the house of a police officer with obviously a lot of connections in law enforcement, and that everyone in this town knows each other, and most of the people involved, the witnesses there that night, do all know each other and have law enforcement connections too?
They're going to go deep into that. That's one of their biggest arguments and strengths. This was a sloppy investigation by the police. You usually don't see investigations this bad. And I mean, coming from the text messages of the lead investigator, which are really negative towards Karen Reed, and show almost a predetermination of her guilt. The fact that police officers were there, they're going to protect the blue code. So a lot of the facts are there to be able to suggest there was this cover up. And the investigation was so bad that the defense is going to argue, hey, you can't rely on this. You know, their burden is beyond a reasonable doubt. How can you have that when you don't really know what happened because of the insufficiency of the police investigation? So they're going to really come down hard on that. That's one of their biggest strengths.
Now each side will get an hour and 15 minutes for their closing arguments. Olivia, Tre, stay with us because we're going to take those arguments in full, but we're also going to continue monitoring what's happening in the other news as we do. But again, right now we're waiting for those closing arguments to happen. Tre, why this conversation ahead? What do you think the judge might be discussing with them?
You know, there may be some last minute tweaking of the instructions. You know, the jury instructions are extremely important. That sets the roadmap for the jury's deliberations, you know, applying the law and the facts. And those can get contentious and come down to the verbiage very specifically. So it's probably something along those lines that the judge seemed yesterday to have set forth what the arguments can be, the scope of that. And so I would assume that's not really the subject this morning. It's probably just fine tuning the jury instructions so they can get underway.
Tre, I'll let you answer that.
You know, it's very tight. You know, an hour and 15 minutes on an 8-week trial, 50 witnesses, all of this scientific evidence, this layperson testimony. You know, there is a lot to break down, you know, in terms of the arguments. Plus, a lot of times when you get to closing arguments, the jury's kind of already made their decision. I don't think in this case. I think it is so close that the closing arguments are going to have a big impact. And in many ways, it may come down to it. So it is a tight schedule. The judge obviously wants this to go to the jury today and get them to start deliberating. I think in a way she keeps mentioning the jury's getting tired. You know, she's very concerned about that. So it is a tight schedule. It's unusual. But since both sides have to stick to it, you know, it's fair.
Tre, could it help them? Because I know there's a lot of information that you want to get in during closing arguments, but also the jury, they're humans with human attention spans. And sometimes it's hard not to zone out when the closing arguments go too long.
Absolutely. You know, the talent behind attorneys and closing arguments is two things: being simple, laying it out very simplistically for the jury, all of this expert testimony coming down in a very easy way to understand it, and maintaining the jury's attention. Because yes, it's very easy to lose them. You know, in this case, it reminds me of one of the slogans in O.J. Simpson, which may apply in this case. If it did not hit, you must acquit. Something like that really resonates with the jury, and they remember going back into that jury, into the jury room. You know, they're going through all this evidence, but something kind of resonates, a slogan. That can be very important.
If it did not hit, you must acquit. Look at Tre pulling out his Johnny Cochran quotes. Well done, Tre.